today I'm happy to bring to campus an old friend and a terrifically talented startup lawyer, Keating Mara. Karen has, and interestingly, one of my colleagues in the innovation pillar, Heather Rose, and she have been colleagues by phone for how many years? A decade, and so they just met face to face this morning, but they've done lots of deals together. So we really are in the telephonic age of deal making, and they've certainly been a part of it. Karen is a really gifted lawyer, but a person who has high emotional intelligence, and you know how we value that here at Jefferson. It's one of the things that Dr. Klasko talks about, is being relevant and meaningful in people that are trying to innovate, whether it's startups or other enterprise-wide initiatives that we're trying to drive forward. Having emotional intelligence means that you can pick up on cues about how you're going to get from here to there. And that's a big deal when you're trying to set up a company, because you got a lot of, Heather's doing this. Yeah, and there's a lot of complicating and mitigating factors. And so it matters that you have good legal advice, and it matters that you have good colleagues that you can collaborate with. Karen has a long history as both a lawyer in the startups world. She was general counsel to Safeguard Scientifics. She runs her own consulting firm now, and she works with a lot of startups. I think also you're still doing a lot of work with Lancaster, one of our new partners. Some of you may know this, but our amazingly gifted leadership team on the startup side, Heather Rose and Rose Ritz, Dr. Rose Ritz, together put a partnership together with Lancaster. You'll hear more about that sometime in the future. We should probably just do a whole event on that, just to let people know what you guys are up to. But in any event, Karen's skill set has real applicability for a lot of the folks in this audience, because if you're thinking at all that you want to be in the world of entrepreneurial endeavor, it matters to have a basic understanding of kind of how you get started and how you move the needle. So without further ado, let me introduce this amazingly gifted woman who I'm happy to call a colleague and friend, Keating Mara.
Turn this on. Good afternoon, everyone. Thank you so much for coming, and thank you to Donna, who has been an innovator for as long as I've known her, which is going back more than a decade, where we've had the opportunity over the years to work together, and she brings a fire and intensity and a passion and intelligence, both emotional and intellectual, to all of her endeavors, as I know you know here at Jefferson. So thank you for the invitation to join you here today. So what I hope to do today is to give you a very broad outline of the considerations you ought to be thinking about in connection with starting a company. It's a lot of information. The innovation folks will have copies of this for you if you want to get a PDF of this presentation. So, because a lot of it, when I put it together, I try to think about, well, what do you kind of need to know, what questions to ask, and when you really do need to talk to someone. Because I don't know that you're going to come out of this today with everything you need. Let's see. Okay, so we're going to talk about, well, we'll go through quickly who I am, but Don already covered that. How you set up, who owns what, the types of investments that you're likely to think about. We all hear about these great, success stories. You've seen them here in this series. Some of the folks in Philadelphia who've been tremendously successful, like Spark. Then we're going to go through common mistakes, and these are the ones where I hope that it'll land in the back of your mind. So when you are someday putting together your company, you'll think before you jump, maybe you pause, because it can save you a lot of time and energy later. So I've been doing this for a long time. This says I've been doing it a long time. I had a finance background before I went to law school, so I did ground myself in a lot of financial concepts and management and operational issues, which really lends itself to kind of being a general counsel to companies, where you're really helping them navigate issues in all different sectors. And then I was at Drinker Biddle, which is called something else now. They just merged. And I was general counsel of a couple of companies before I started my own firm back in 2005. Because I really wanted to be that a partner with my clients without kind of the overhang of a big firm. So jumping right into it, if you have a concept and you think, whether it's something that's coming out of your research or something that you just, you come up with, you see a hole or an opportunity in the marketplace. Well, how do you organize? Now, one of the ways of operating a business that's not on these slides is a sole proprietorship, because it doesn't offer you any protection from liability, and it's not viable for growing or scaling a company generally. So you have to think about, there are two types of companies that people decide to utilize. One is a corporation, and one is a limited liability company. So we're going to talk a little bit about the difference between the two and some of the considerations you can think about. So there are two types of corporations. There's a subchapter S Corp, which is basically, it's kind of like a corporation that's taxed like a partnership. But I guess I should step back for a moment and say, these entities, these organizations, the reason one does this, the primary reason is to protection from liability, so that the owners of the entity are not personally liable for the obligations or liabilities of the company. So if you're a sole proprietorship or you're a consultant and you're just doing your own consulting work in your name, if you, depending upon what your contract says, if you do something and it's a mistake, the person on the other side of that contract can go after you personally, and then all your personal assets are theoretically, are at risk. Whether someone actually does that or not, it's not terrible, but that's kind of where we start. So corporations are creatures of state law, and so are limited liability companies that encourage innovation by providing a platform to grow ideas, knowing that the individuals who are running it or owning it are not personally liable for those obligations. So once you decide you're going to incorporate or organize in some fashion, you have an S Corp, which is not only, it's a limited, you can only be an individual, meaning you can't have corporations as stockholders in S corporations. So for the most part, you don't see them in our world, in the startup world, because lots of folks, there are lots of entities, partnerships, venture capital funds are typically organized as limited partnerships. There are groups of investors that are limited liability companies, and then corporations, as you probably see, make strategic investments all the time. So the S Corps kind of come off the table, but they do exist. For consulting entities where it's just you and a couple people and that's all you're ever going to be, they work. So it's something you can think about in that context. A C Corp is a corporation. You issue stock. And one of the key differentiators with a limited liability company is that when you generate losses, which most every startup company generates for at least the first few years, they're captured within the corporation. And the corporation can offset income later when it has revenue with those losses, but the individual shareholders don't get the benefit of that. They just own their stock certificate, and they're really hoping for either, in most cases, the appreciation of capital, meaning that when they buy it at $1, it's going to be worth $10 someday, and they'll have a way to monetize that, versus dividends, which is the other way corporations can distribute cash to their holders, but then that's subject to, you're going to pay tax at the corporate level and the dividend level. So that's not, and in the startup world, no one's looking for dividends, on a current basis. The corporations do have some benefits too, in the sense, well, there are lots of benefits, but one of the things in the startup field that makes sense is that, as I'm sure you know, everybody, if you're investing or a part of a startup, you want to have a piece of it. And so how do you get individuals, your employees, your consultants, your board, a piece of it? And that's usually through something, like a stock option plan or an equity incentive plan, where you grant individuals options or restricted stock or other instruments. Using a C corporation, that's really easy. Like, there's a set way of doing this. Everybody understands, most people understand a stock option. You can Google it. You can see how it works. And there's a type of stock option called an incentive stock option, which has some tax benefits. It's not taxed as, it is preferential tax treatment versus something called a non-qualified stock option. So there's some tax benefits to organizing as a corporation, where you can operate without liability. You can issue shares to both your contributors as well as your investors. Everybody understands that. There are form documents that are out there that people work within. One of the resources at the end of this presentation is that the National Venture Capital Association has a form of Series A documents that kind of show you this is a standard that many, many, many companies use. So there's a lot of, and there's a deep understanding and a deep basis of case law that governs corporations that there's a lot of confidence in. And most people select Delaware for that reason as the state of incorporation, because they have the best case law, the best statute, and they have one of them, if not the most experienced and intelligent judiciary. So if you're ever fighting about something, you want to be there. You file with the state. You file in Delaware. It's a certificate of incorporation where you basically have to say like how many shares that you're authorizing and where are you located, and all, there's a couple of key things that the statute says you have to have in it. It's pretty easy to do. You have a certificate that's your certificate of incorporation. And then you have other documents like stockholders agreements or other investment-related agreements that I'll get to later that govern, well, how are we going to do this? You have your bylaws, which will say how you're going to meet, how you're going to decide things. Some of those provisions can be in your certificate of incorporation too, but you have a set of governance documents that you'll adopt, and you and your board, which is the governance mechanism for corporations, will use those documents to guide their actions. One of the things I mentioned, though, like when you say, okay, you're going to start a company, is once you file with Delaware, which you can do on yourself, there are services that do this for you, but you can do it yourself fairly easily. Then you're on track. You have to make annual filings every year. And you're going to get a piece of paper from the state of Delaware saying if you say you have 1 million shares authorized or 10 million shares authorized, you're going to get a bill that's massive saying you owe, several $100,000 of tax. You don't. But there's something called a capital stock tax in Delaware that's generated. There's other ways of calculating it. So as an aside, one of the first things you should do is make sure you have a good tax preparer who's going to help guide you with these things. And that's true whether you're doing it as a corporation or a limited liability company, because a lot of these things are tax-driven at the early stages, and they're not intuitive. So making sure you make those filings, you make them on time, and you do it in a mechanism to minimize your tax makes a ton of sense. So I put together here just kind of a summary. We don't need to go through it all, but let me see. Should we go? Let me just see something real quick. Okay. So this is me. They're in the wrong order. Here's a limited liability company. An LLC is like a corporate partnership in the sense that you are given in a partnership, the members have liability to some extent, depending on whether you're a limited or a general partnership. But a limited liability company, also a creature of state law, you're protected from the debts and obligations of the organization. The benefit, though, is that when you generate losses every year, the company is going to distribute them to the members, who are the equivalent of stockholders. And that can be really beneficial in an early stage, like this, things that I see most often of startups that come out of university tech transfer deals, just entrepreneurs who are building a software platform, and pharma deals where you have a compound that that has already maybe come out, but you've got years of development ahead of any sort of real commercialization opportunity. The money that you raise from whatever source that's spent on various expenses to develop the technology or the compound or the device, at the end of the year, those losses can be distributed to the owners, and that offsets their income. Particularly for founders, I found often founders self-fund, and so they'll have written. Not only are they given their time and their energy and their IP, their intellectual capital, they're actually putting money in. And this is a way to say, okay, I'm writing this check, but then you get at least the benefit of those losses to offset other income on your tax return. And angel investors more and more, I'd say over the last 10 years, there used to be kind of common or accepted common knowledge that if you're going to raise money, you want to be a corporation. But over time, in the last 10 years, I've seen more and more of the angel community be very open, in fact, prefer an LLC prefer is maybe too strong, but they're equally happy to invest in either, and then they're very happy to get the losses related to their income, because many of them have a broad portfolio, so there's always something to offset. I think of it a lot in terms of the founders, though. That's where I see a lot of the benefit of an LLC in terms of its tax treatment. The complicating factor there is simply that when you do the equity grants to your member or your employees, it is complicated because it's a partnership, and so you can get instruments, you can do options, you can give options in a limited liability company interest, and you can also give something called a profits interest, which is it's a tax beneficial instrument that you don't pay any tax when you get it, you don't pay any tax when it appreciates, and when you ultimately liquidate, you get capital gains treatment. So it's really a good instrument, but once you give those out, you're a partner, and therefore you're not a W-2 employee. So you have to pay your own self-employment and FICA tax on, as opposed to the company paying it for you. So for for the founders, they get that. They're partners. They get their something called a K-1 instead of a W-2. But for rank and file employees, I think it's really confusing. It's very hard for them to understand. So I think it's a consideration to pause and think about when you're making this distinction, how are we going to use equity? Are we really going to give it out? If you're not going to give it out to a broad number of people, then an LLC probably is going to work just fine for you. The other thing about the LLC is that it's really governed largely by contract, meaning in something called your limited liability operating agreement, you can decide how things are done, who gets to vote on what, who doesn't get to vote on anything, how it's going to work, how money is going to be distributed, how losses are going to be distributed. Things that are governed by Delaware corporate law can be done by contract in an LLC, so you have a lot more flexibility about how complicated or how simple you want to make it. And so that's another benefit of an LLC organization, that it just gives you a lot of flexibility. And then at the end of the day, you can always convert to a C Corp. So you're not giving up that opportunity. You're just saying for these, for a period of time in the life of my company, I'm going to organize this way. So same thing, once you file, you're not going to get a capital stock invoice from your state, but you are going to pay an annual filing fee. I think in Delaware, it's like $300 or $400 a year you have to pay just to exist. And that's why there are no income taxes in Delaware. Okay. So we'll go. So I created this little chart that just kind of shows, if you're thinking about how you want to organize, these are kind of the distinctions, some of the considerations to think about. For instance, in an S Corp, you can't have multiple classes of stock. So again, it's not really relevant for purposes of startup discussions. Are there the restrictions, how it's taxed? They all have the liability protection. So something that, if you take this away and you're looking at it, these things can help you think about what you want to do. I will tell you, what I see most often these days, the companies that I'm representing or who come to me, I would say 75–80% are LLCs at the earliest stages, and then the rest are corporations. If you think you're going to get third-party financing from like a fund within a year or so, 18 months, then you probably should be a C Corp. They prefer it because there's something called unearned business income tax that can float. That's a problem for limited partnerships who have pension funds and ERISA-type organizations as holders or members. So I think that's kind of a good way to think of it. If you think you're going to get, and some people do. Some people have these ideas and they come out of, they've developed so much in the lab that they are ready and there are people lining up to invest. Then you want to be a C Corp. If you're going to have a longer run, you're not quite sure, you guys, the founders are going to be guiding the ship and maybe making investment, then an LLC is probably the way you're going to go. So once you've decided how you're going to organize, then you have to figure out how you're going to pay for it. Like, who's going to pay for what? And what do they own as a result of it? You have to think about, you will have startup costs to finance. I mean, if you do everything on your own, it can be nominal in the sense that it's a couple $100 to file. You do need someone to do your tax returns every year. That's at least $500–600, but it's not onerous. And then you have to decide, how are you going to fund your activities? In most cases, again, the founders will either work for nothing and just kind of earn into their equity, or they'll loan money or contribute capital. So when you contribute capital, you're not expecting to get it back right away. You're only going to get it back if you have if there's some liquidity event, which is a sale, could be an IPO. I mean, there's more of those happening for the people in our, in companies, although several stalled nationally this year. But when you contribute capital, whether you're purchasing stock or whether you're making a contribution to capital in a limited liability company, you're not getting that money back until there's an exit. If you loan the money to the company, you might, depending upon the terms of those notes, and then your incoming investors at later stages, you could get that back sooner. So in many cases, founders use a combination of that. I mean, when you get to the point of attracting third-party capital, investors do want to see that you do have skin in the game, that you've both contributed your time and your resources to making this a success, and that you're incented for the long term in terms of your equity ownership going forward. So you will need to figure that out. what's important here, and what you might, a takeaway is simply however much you decide to put in or how you want to document it properly. And that's the part where it gets, entrepreneurs are wearing multiple hats. And this is like, 20th on their to-do list of making sure that it's documented properly. But it can have repercussions if you never get around to it. If you want to, because this is going to set your basis in your interest in the company. It's going to document that what you got and what everybody got. And then what are the rights or obligations related to that. So it is really worth making sure at the front end, when everybody's friends, everybody agrees, that you're all, particularly as it relates to founders, you're all going to invest on the same basis. So that one of the things I strongly advise folks to do is to make sure you have a way of getting it back. So if everybody, what we see all the time is that in a partnership with, say, 3 or 4 initial founders, there will be at least one who doesn't do what y'all think he's going to do or she's going to do. And then you're stuck. They may have 25% of the company, and then if you haven't planned, they're there on your cap table forever, and they get the benefit of your efforts, unless you've outlined at the front end, okay, this is what we expect, this is how you invest, or this is going to be the obligations that we expect of you, or we get to buy it back for what you paid for it, which is virtually nothing. And there are lots of, you're going to see that theme throughout this, because I find that's one of the things that people forget about at the front end, because everybody is so excited about what they're doing. But all good things come to an end in personal relationships often, and folks lack emotional intelligence at times to make and wanting to have those harder conversations up front, but it's always better to do so and have a way of getting your equity back. And these are the kind of things that you'll need to do in terms of allocating your equity so that you can document it. You're going to want to you'll want to subscribe for the shares. So you have a piece. These are not complicated, but it says I'm buying this for this amount, and for a company, you just have to pay par value, which can be hundredths of a penny. We're not talking about. It doesn't have to be a significant amount of money at the front end, and you want to make sure you start on QuickBooks or some platform like that, because it makes it so much easier for you. It's really worth, I think, spending the time to get smart about that, or have someone on your team who can, so that it's not just you saying, well, I've put in $20,000. When you put it in, because you've recorded it, because that also often becomes an issue as well later down the road when you're in diligence for a deal and you don't have any backup for anything that you've verbally communicated to your potential investors. So again, you have to subscribe for par value. It can be a tiny amount. And one of the things in an LLC that I think you can think about is that your economic rights and your your economic rights and your voting rights, they don't have to be the same. So it's not necessarily proportional. Each class of stock has to have the same rights. In a C Corp, you gotta, whatever your rights are, that whole class or series is the same. In an LLC, you can really get it crazy if you want to say, okay, I have 10x voting, for every one unit of mine, I get 10 votes and you get none. And that's okay, you can do that. And sometimes that's how people manage through who's going to contribute the most. If you need their money but you don't really want their input, you can use different, you can have different voting rights or different classes of units to manage through those issues. One of the things I like to just mention to everybody is that I often see founders who, they've been working on this concept for years usually before they actually start a company. And they have very high expectations about what that's worth. And when someone like an angel investor says, okay, I'm going to give you $500,000, or a group of angels say that, but they want, it's at a valuation that you don't like, or you're diluted, they walk away and they say, no, that's not right, but it's really only worth what a third party is willing to pay for it. And while you certainly want to be mindful of the fact that there are people, you're on the opposite side, they're going to try to get as much as they can, and you want to retain it. I often see founders have predetermined notions of what they should have at the end of the day when they look at financings, and it prevents them from making good decisions sometimes, because there are more ways things can go wrong than go right. And so when you do have opportunities to raise capital at reasonable rates, you really ought to do it, because otherwise it's on you, unless you can self-fund, in which case if you can do that, then no worries. But I do find that founders often have an idea that they need to have 40%, 50%, after a certain period of time in order to, and that's not realistic. As I mentioned before, one of the biggest things I want you to think about is when you start something, to make sure you have a way to getting it back. So when you you enter into your subscription agreement for shares or units, you say that these units are subject to buyback by the company if I leave, which means, whether you get fired for cause or whether you just decide to do something else with your time. Just want to make sure you have those built in. And again, just like I've seen people, and it's specifically I see it more in the tech transfer space than I do in the entrepreneurial space, where people get very obstinate about what they think things are worth, and that ultimately doesn't serve in many cases, the technology or the drugs that they're developing. So moving on to, it's time to have investments. You want to have third parties join you in developing your concept or your technology. There are different instruments that you should be aware of, and a lot of these you can find additional information online. But what you'll see is that there's something called a SAFE, which is a simple agreement for future equity, which is basically a right to, you give the company a certain amount of money, the investor gives it money, and they have the right to convert into the next round of equity at a discount. So they don't get any, it's not like a promissory note, so there's no interest, but it's a right to participate. That's originated, like most things in the venture space on the West Coast, but in the last couple of years you see more and more of them here in Philadelphia on the early side of investing, where if you're, you can raise money without having to pay interest, which really does accrue at a good clip. So that's one instrument. That's kind of the most preferable one if you can use that. Simple, gives the people the right to participate in the next round, and what it avoids is setting a valuation. So when you raise money for a company and you're going to give away a part of your stock, your equity, you have to determine what it's worth. And so you have to develop something we call a pre-money valuation to say the company is worth, $1 million, and so based on the number of shares or units outstanding, what is a share worth? And that's what people are going to pay when they invest money. But as you can imagine, what founders, and often at early stages of whatever you're developing, it's virtually impossible to come up with a real valuation that is objective, because there are no cash flows, there are no comps. It's very hard. It's all based on assumptions, to determine an enterprise value. So using something like a SAFE avoids that discussion. We're saying we're not going to worry. We believe in this. We believe in you as a team. So we're going to give you this money, and then we will get to participate when you get to that point. When a third party is able to, based on your achievements or where your technology is, what milestones you may achieve, when you can come up with a more rational way of determining a valuation that both sides will participate at a discount. I'm kind of going in reverse order. Another way of avoiding a valuation is issuing convertible debt, and this is a very common instrument. Angels like this generally, because not only are you converting into this next round, whatever that valuation might be, at a discount, which is around 20% usually. And this is what Ben Franklin does, Ben Franklin Technology Partners, who's a big funder of a lot of early stage ventures. This is the mechanism after you do their initial kind of seed grant that they most often do, is they have a convertible instrument like this. But it also accrues interest at anywhere from, I've seen as low as 2 and I've seen as high as 8. And that accrues a lot. So when you're doing this, if you raise your capital in this convertible debt instrument, and you don't actually convert for another 2 years, that's all, it's a couple hundred. You can easily accrue another 100,000 plus of interest-related dilution because of that interest component. Plus, you're giving them a discount. So I've seen deals, and I've seen, Ben Franklin as an example, where I'm looking at it from an investor's perspective, and I see who came in early, and now we're doing a round. There was one I did last year where it was a pre-money valuation of $15 million, but the early investors' convertible debt had them converting it of a cap at $5 million. So they got an enormous amount of shares versus the folks who were paying current value, and the deal still got done, but it was an extreme example of how the provisions in a debt deal can be really beneficial to the investors, and not great for at the end of the day, the new incoming investors can make that investment decision. Some will try to, sometimes, less likely now than in the past, they'll try to say, nope, you're not getting the full value of that. We're going to agree, we'll put the money in if you decide your discount is, only 20%. But the people, where this really impacts you is on the founders, because there's the dilution that every bit of equity that you issue, ultimately management's piece does get smaller and smaller. And so you really, as much as you want the funds, and you have to be reasonable about what's available to you, I caution against just being mindful of convertible debt, which could be outstanding for a couple years before it converts, and what that pro forma impact on your overall equity holdings can be. And then at last is just equity. This could be stock or interest, membership interest, or units. You can have different series, and they will have different terms. But you basically say the company's worth $5 million, and I'm going to issue 20. I'm going to invest. I'm going to get 25% of it, and everybody. Then you redo the cap table to show the dilutive effect of the new money coming in. So these are the kind of terms you're going to see when you get to that stage. So we've kind of talked about, and I know this is a lot of information, but we've talked about the type of organization. Now we're talking about the types of financing instruments you can use, the equity, convertible debt, or safes. Now, regardless of what those are, this is what you're going to see. These are the kind of terms you're going to see in a term sheet, which you would get from a third-party investor. They would identify which kind of security we're going to do, what the valuation is, how much are you raising, $1 million or $2 million, whatever that is. It's usually, it can be anywhere from $1 million plus. You don't usually see term sheets, sometimes, but for less than $1 million, but occasionally you do. Whether there's going to be a dividend associated, which is kind of an corollary to interest, but in most cases, it's only payable upon liquidation, meaning that you're not paying it currently, and it doesn't, it's not declared every year. So they exist, you see that a lot less. Most of the deals that I see in the equity space, there's a small or no dividend. In the LLC, it's called a preferred return. There's just different nomenclature. Voting rights are a big deal because they determine a lot of times when you have a third-party investor to come in, they're gonna say, okay, I believe in you, team, but now I'm gonna be a part of that team too on the board. So I get a board seat, and there's gonna be a list of things maybe that you can't do without my agreement, which you have to. That's a negotiated term. A lot of cases will be you can't issue any other security that's better than mine. Has better rights than mine. Is senior to me. You can't do a change of control transaction. You can't change the comp of the officers and directors without me agreeing to it. So there's a whole list of things that a third-party investor is now going to say, okay, you've got my money and I'm invested, but I want to make sure you don't make any mistakes with my money. And I want to agree to, or you can't change your business plan. So you can't take the money and decide, okay, we were going to do this and now we're going over here and thanks, but that's typically prohibited. If it's debt, you're going to put the conversion triggers in, meaning that this is convertible debt, so when does it convert? And typically that means you'll set at the front end that when you raise equity at about $2 million or more, that's usually what the qualified financing is defined as. This debt will automatically convert, so nobody has to worry about going back to them. It automatically converts, and then which is good because as your debt's on your balance sheet, and people will look at your balance sheet as you grow, meaning, if you've got a ton of liabilities and like this much of your assets, and in an early stage, the assets are kind of goodwill and IP, and they're intangibles for the most part. You're not going to have a lot of cash, but you do want to be mindful of your balance sheet, and clearing out your convertible debt is a great way to kind of reset. You get a clean balance sheet, and that will often, after you've gotten funding, usually it's Series A, you'll be open to like commercial banking. You'll be able to get a working capital line at a bank then, so you don't have to worry about making payroll, which is a huge issue for startups. Which we'll touch on in a minute. But and then there will be these other rights, which registration rights, which have to do like if you go public, like how do the guys and girls who invest, how does their stock get treated? How do they get registered shares or not, so that they can participate and trade on the open market? right of first refusal, meaning that when you raise debt, most companies, you're not going to just raise money once. You're going to raise money multiple times. So most angel and all institutional investors are going to say, next time you do it, I get to buy my portion of it. And then oftentimes you'll have people competing, that people want more than their portion, and then you're kind of trying to figure out who's got rights to what. But you are that's what you can expect. And then I'll just mention drag-along rights, which are an important right, which mean that, you founders will have your slug of shares, and then you have the investors coming in who probably won't have a majority, right? They're going to be in a minority position in almost every case. And so if there's an opportunity for a sale, you founders might think, no, we can wait to IPO. No, we don't want to sell. We want to do this. But financial investors are like, no, we're good. We'd like to get our return. A drag-along right is embedded in your investor rights agreement or in your operating agreement, which says if there is a transaction that's approved by, could be the board plus the preferred stock, everybody who's a shareholder who signed this has to agree to sell on those terms. And so you get dragged along. And that's good for the company because otherwise the investors don't know how they can get out because they're probably not entirely they're not in a controlled position. But it's a concept that you should just be aware of because sometimes founders see that and they just react to it a little bit. And then there's an equity compensation pool, which was the pool of shares that you're going to allocate to incent your employees with stock options or other instruments. Okay, so common mistakes. This is what I see most often. When you're starting up and you start a company, you can file with LegalZoom, you file your papers, and you're good to go. And you start saying, okay, friends and family, you want to have a piece? You want to invest? There are securities laws that every issuance of stock or equity has to comply with, and it's not intuitive because you're like, well, what do you mean? I'm like nothing yet. I'm just this idea. But it doesn't matter. If you're issuing equity, the federal and state security laws apply, and you have to have an exemption from registration. So basically, in the 33 Act, the Securities Act of 1933, to curb abuses that were going on with stock plans before that precipitated the Great Depression, people were saying all sorts of nonsense, making up stuff. People were putting in money, and it blew up. So now the SEC came along, was organized, and they said, if you're going to sell shares, you have to register them with us. And there's a whole list of what your registration statement has to include, which no startup could ever do. So there are exemptions from that, but you have to comply with them. So there are exemptions, like in Pennsylvania, you can issue stock to up to 5 people in a connection with incorporation. So you don't have to, you don't have to do anything else. And on the federal scheme, you have to really know what's going on. You have to be sophisticated, you have to understand what's going on, and you can be exempt from the federal stage. But this isn't easy, this is complicated stuff, and I can't tell you how often every year I am called in to fix these things where people in good faith don't know about it. And so they issue shares, and the problem is, later, you have to disclose, first of all, from a regulatory perspective, the SEC could go after you. And if you did it a lot and it was fraudulent, you could go to jail, potentially. But more importantly, when you're trying to raise money, you have to represent to the investors that I've done everything right. I have issued everything in accordance with all applicable laws. And if you haven't, you've got an issue with you're not going to be able to raise the money. So if you can't make that statement, you're not going to raise, they're going to make you fix it before they give you the money. Or they're going to want to understand, well, how big a deal is this? How much have you done? And then how do we fix it? So I really do caution you when you're issuing equity for money from third parties. And they really ought to be something called accredited, meaning that you should not be issuing stock or equity to people who are not wealthy enough, and the SEC has a definition, meaning that they either individually make over $200,000 a year for the last 2 years and anticipated, or $300,000 with their spouse, or have net assets of at least $1 million, not including the value of their primary residence. That's someone. There are other categories. Or you're a director and officer. If you're an executive officer, that's okay too. If you're not in those categories, you really shouldn't be selling your stock to these folks because they're not. First of all, there's no exemption probably, and they're not. These are very high risk endeavors. 8 out of 10 at least fail. They don't get to the place where you want. So. You want to make sure that you're not offering these things to people or inappropriate. But my point generally about this stuff is that this is an area where you really do need to call a lawyer. And you need to call a lawyer who's not your real estate lawyer, because I get calls all the time, and I do a lot of different stuff too. I read leases, I do other things, but this is one where I still trip upon colleagues of mine who are super smart people in their fields, and they've helped out a friend with a company, and they didn't know about this. So when you're raising money, no matter how small, it's worth spending some time with an attorney to make sure you do it right, because it will have repercussions if you don't. Similarly, when you have your stock option plan or your equity comp plan, same thing. To have those issuances have to be exempt from federal and state registration requirements. And in most cases, in most states, to do that, you have to have a written plan that has been adopted by the equity holders within 12 months. So they mostly have a written plan, but they probably have, not everybody has gotten it adopted by the members, even though it would have been perfunctory and fairly easy at the early stages. And if you don't, those issuances are not exempt. And there are also states like California and Virginia, but California sticks in mind most clearly, where you have to make a filing with the state of California before you can issue stock options or any equity to a resident of California. Similar, say you have a board member from California. You can't give them, or an advisor, a scientific advisor, you can't give them equity until there's a filing with the state of California Securities Office. So that's a mistake I see very often. And then the last thing in terms of the equity comp is it's really important to track it. You're going to have to report this to your current and future investors. They look at this number a lot because they want to make sure when they're investing in your company that you have a tool to attract talent and to retain talent. And if you've given it all out, they're going to make you refresh your pool, and they're not going to take that dilution. They're going to want you to do that before you do your investment. So that's just another way you'll get diluted if you've given it out too freely at the front end. So you want to make sure you know how to track it so you can feed your cap table. And I should have said a cap table is a capitalization table, which is simply a table that shows all your investors by name or category, and then what they own, and what their percentage is at the end of the day. And that's a really important tool that most investors are going to see in documents. They usually ask for it they ask for it quarterly, but you're certainly going to have to produce it annually. You're going to need, when you're granting options, stock options in particular, and if you're granting them to advisors and consultants, there are tax implications if the value changes between when you grant it and when it vests. So you're going to want to make sure your accounting team is fully, and your tax preparer is fully apprised, and that you have a tax preparer who understands this stuff. So not everybody has this skill set where they can handle your personal taxes and then they also understand how to manage the company, which has multiple classes or types of equity that's being granted. And then one important point, and people try to get around this all the time, but if you issue equity to someone under a stock plan, you are prohibited from doing it is compensation for raising money. So people who raise money for companies, and there are people out there who call themselves merchant bankers or business development people, they'll say, I can raise money for you, but I want X% of it to do it, so I get a percentage of whatever I raise. You can't do that unless that person is a registered broker-dealer. You can give equity to consultants who do a lot of things for you, which might include that, but they better be doing those other things for real. It can't be just on paper. So I just want to keep that in mind, that you can't give out equity to someone who says, oh, I can raise $3 million for you, but I want, I want options worth, 3% of the money that I raise. You can't do that. But people ask for it all the time. We talked about this before, so I won't belabor it, about you always want to make sure you have a way to get your equity back. Be cautious. Business develop people. So when you have your company and you're going around to the various, maybe you're going to a PAC event or other places and you're meeting investors or you're meeting business development folks who are in this ecosystem, a lot of people will tell you, oh yeah, I can do this for you. I know how to do this. I'll run this for you. And then they want you get their terms and they want 5% of the company to do it. And if you're going to, if someone actually joins your company as a CEO or a senior position and is able to do that in addition to something else, well, that might be worth it. But in most cases, what I've seen over the years is that folks promise a lot and underdeliver. And so then again, if you haven't structured this right, they're walking out the door with a piece of your company, and it's difficult to get it back unless you've done it at the front end. So we talked about the options for fundraisers, and there are, as I mentioned, in terms of talking with a lawyer too, a lot of, as you're hearing, as I keep saying, a lot of this stuff is tax driven. And again, it's not intuitive. So there are tax implications about when you get stock. So if you get it at the front end and you pay par value for it, that's fine. But once there's a value as accreted to the company, and you want to grant stock, like you want to issue stock to someone for their help, which is perfectly fine. If you have an incoming CEO and they want 5% of the company, that's okay. I mean, it will probably vest over 4 years or some period of time. But if they want to get something called a restricted stock unit, which means they get the full value of the stock now, they have to take into income the value of the stock right now, even though they don't have it all, and you have to make something called an 83B election with the IRS. So how much the company is worth when you grant equity can affect dramatically how you grant it and how the recipient's going to be taxed on it. So that's why it is important to make sure you have people on your team who understand this stuff. That could be a CFO type folks who have worked in this area do understand this, but granting equity to people, if it's not in the form of an option, or particularly an incentive stock option if you're a corporation, or a profits interest if you're a limited liability company, can have serious tax ramifications. I have one. I have a company right now that's raising money at $10 million, and they just hired a CEO. And they wanted an option, then they saw what they flipped to a profits interest, which basically is an instrument that says I'm coming in now while your company's worth $10 million, so I can get 5% of the company, but I don't participate in anything until the first $10 million's gone out to the pre-existing investors. So you're only participating in the profits from that point forward. So it's a different instrument, but you don't, that first 10 million, which may be all there is, you don't play in that if that's the instrument you select. One of the areas I think you all should think about, and particularly folks here, is intellectual property protection. It's important. I mean, it couldn't be more important to make sure everybody you interface with, that you've contractually gotten them to agree to keep your information confidential. And that's for both competitive purposes, it's for patenting purposes. It has myriad reasons to make sure that you don't just start engaging with someone before you put these in place. And if it's with someone who's going to actually contribute to the development of your intellectual property portfolio, you want to make sure that those agreements have an assignment of inventions clause in them. And that's a clause that says anything I do for you that I'm getting paid for, that you're using your resources or your confidential information, that's yours. I'm hereby assigning it to you now. When you go to raise money later, or you go to sell your company, that trail of ownership of your intellectual property capital is critical. Being able to show an unbroken chain of ownership that you've contracted. So for anybody who's contributed, you've gotten that agreement in place at the right time or with the right language. That's critical. I'm doing a deal right now where it's a Series seed, and there's like 3 people we're not doing the closing yet because we've got 3 people who they didn't get it from. So the investors who are putting in like $3 million, they're waiting till that's done. And so the company's got to give something more than they would have had to give to get it. So it's just, you can clean these things up most of the time, but it's best to do it right from the outset. And of course here, I think what's really important to keep in mind, and you probably all are aware of this, if you're developing it here in connection with your role here at Jefferson, you've got to be mindful of the Jefferson patent policy and making sure you're doing it in a compliant manner, and making sure you're interfacing with Heather and her team to make sure you're doing it right, so that there isn't any, first of all, that you just don't want to have misaligned expectations, but there are ways there's things you get if you do it for Jefferson, and then if you're outside of Jefferson, and you have to be careful of that, you really are, then you can go down a different path. But making sure you're very clear on those at the outset is very important. For those assignments, for employees, you can have continued employment, meaning if you've already employed somebody and you didn't, your person didn't put that in the offer letter, you can go back and say, okay, in consideration of us deciding to continue to employ you, because here in Pennsylvania we're an at-will state, you're going to do this. That's not true everywhere, but it's mostly true. And you want to make sure you have the right language involved. Like meaning that you are sometimes I read agreements that says, I will assign. Well, that's great. Now I got to go get you to it. Like I have a contractual right I can enforce later that you actually will assign it, but it's still yours. You haven't actually assigned it. So I like to make sure that people, when they're signing these, it's like you're hereby assigning what you have, and and it's a continuous covenant to assign in the future. So you have to be careful with the language a little bit. And again, when you're entering into contracts with third-party it might be your vendor, might be a potential investor, could be really anyone. You want to make sure the NDA that you've read it. I mean, they all look kind of the same, but they say very different things. And I will tell you, there's one that sticks out in my mind, and it was for a major pharma in this area that I read for a client, and it was called an NDA, and it literally said in it, anything you give to us, we have full rights to use. So it was like an anti-NDA. It literally said we are allowed to use this stuff in like paragraph 7, which we've all stopped, everybody stopped reading. And it's one of those things you read it like, this can't be right. And it was absolutely right, and it was a company you all know. So you can't make assumptions, you have to literally read them. Make sure that you've protected your trade secret. A lot of stuff gets developed to protect it now as trade secret, meaning you as a company decide not to patent it, but you would like to keep it secret. And sometimes you do have to, there are things you have to disclose to third parties. You want to make sure that the NDA lasts for the length of the duration of how long that information is protected as a trade secret. Not just, a lot of these agreements will say 1 year, 5 years, 3 years. You've got to have special language to protect your trade secrets. And also, one of the things I rail against, sometimes effectively, sometimes not, is that everybody wants a mutual NDA. But if you're not getting anything from the other side, it doesn't need to be mutual. Just say, if you're the only one giving stuff, then the other side should just have an obligation, to keep your stuff confidential. You shouldn't have to agree it's mutual, because then you add in an ambiguity where someone could potentially raise, no, I gave you that. And, I just think, keep in mind, you want to be mutual, people think it's friendly, but if it's not applicable, then I wouldn't recommend it. Here are some common mistakes with regard to once you've gotten to the point where you've formed your company, you've gotten some funding, you're developing your IP appropriately, and you've got to hire people to do it. So startups are often, thinly capitalized, meaning they never have enough money, but they hire people as employees. And what's important to know is that, and I've had many clients who stop paying people, like their senior staff says, okay, we're running out of cash, this contract didn't come in, I won't take a salary. That's nice, but the labor laws of the US don't think that's nice. They don't in fact, it gives the individual employee a right of action against the company for any unpaid wages. And depending upon how bad it is, you can have director and officer liability for that. So you have to be mindful of the fact that if you agree to pay employees something, you have to pay them. Or lay them off, have them agree to change their compensation. But you can't keep saying they're employees and just not pay them. There are significant liability issues that accrue, and under the law, under the wage payment and collections law, they get their attorney's fees, so they're plaintiffs' lawyers who will take those cases, and you don't have to write them a check. And I've been on the other side of those where people do everything in good faith. They just think, well, we didn't have the money. They don't care. It doesn't matter. There's still liability, and that can tank your company. Another thing is you can't, or you say at the end of the year, okay, we don't have the money. You keep it on the balance sheet. You keep deferring it. When we get it, we'll pay you. When we get it, you're not allowed to do that either. Under Section 409A of the IRS code, if you don't pay somebody what they've earned by March 15th of the following year, both parties are subject to a 20% penalty on that, what was not paid appropriately. And I always think more importantly, is that when you raise money, you have to make reps and warranties to your investors, and they're going to say, I've complied with the law. Well, if you haven't complied with the law, then you're taking money and, could be deemed fraudulent. I mean, and then you're in real trouble. This is getting into the weeds a little more, but I'll just mention it to you as well. Employees are a whole area of law. I mean, when you have employees, once you have W-2 employees, definitely hire a third-party payroll provider to take care of this. They will also provide you with notices you need to post in your offices. But There's also an issue that we see in the early stage space. Okay, do you hire somebody as a consultant or as an employee? And there are reasons, employees have a lot more rights, so people like to avoid that because it's expensive and you have to do withholdings and you have to comply with kind of a whole category of laws. You can have people consult for you, but if they are actually if you're calling them a consultant and paying them as a 1099 consultant, but they're actually under your control doing what you say, where you say it, when you say it, they're an employee, and the IRS and the Department of Labor are not gonna. If this gets looked at, they're gonna disallow that classification, and that is something where that can become a real issue. So certainly at the front, when you're really first starting, when you're pulling together the different pieces that you need to develop your company, hiring consultants is fine. But when you're continuing to do that because your CEO just wants to be able to write off other expenses, he runs through his company even though he's working for you full time for the last 9 months, that's not going to pass the snuff test later. As an employee too, you have minimum wage requirements, which believe it or not, can be an issue, and whether people who work for you are classified right, as whether they are exempt or non-exempt, is another big area where people get it wrong. And I had a client locally who had their office manager classified as an exempt employee, meaning they were exempt from the overtime requirements, so they were just treated as a professional, and they weren't. But then this person stole from the company, not a lot, but stole, so they fired him. And then they got a lawyer and said, a class action attorney filed a suit in federal court saying, you've misclassified us, and me, and therefore I'm suing you for, all sorts of things. He was right. They were misclassified, so they had to write a big settlement check. So it's important. These things do have and people, again, I mention these as mistakes because these are made by people who are doing things as best they can, in good faith, not intending to do anything wrong, and yet they fall into these traps. These are kind of the basic documents that you'll need when you're starting a corporation. So because I mentioned you'll have an articles articles of incorporation as PA, certificate as Delaware. You'll have bylaws, which are fairly standard, not very interesting. Operating agreement, which can be very interesting and can be, as simple or as complicated as you like. You want to make sure you have a good employee offer letter, which has attached to, as a condition of their employment, has whatever covenants about confidentiality, invention assignment, non-solicitation, or in some states, PA and New Jersey, you can in Massachusetts or California, non-competes. Your non-disclosure agreements, your NDAs, we talked about whether they're mutual or unilateral, and then just note it that there are a couple resources. There are many others you can find online, but if you go to ycombinator.com, they develop the SAFE instruments, and there's a lot of information there. And that's a really good site just for general information about startups. And the nvca.org has a lot of great resources too, just to get you, you can look at the stuff I've reviewed today, but as you're approaching these different inflection points, you can refresh your recollection and know what questions to ask to make sure you're doing it right. So I'd be happy to take any questions that anyone has, but thank you so much. I hope it was interesting.
If anybody has any questions, we have time for a few.
Yeah.
I just want to say, Karen, I was starting to have flashbacks. Karen represented me a million years ago, and I was helping to raise a fund, and it turned out that I had a rogue lawyer. So I would also caution you against having a rogue lawyer who may not do all the things that need to be done for whatever your business circumstances are. And she bailed me out, saved my deal, and I got paid.
Yeah.
So that was all good. I saw a hand back here.
Hi, my question is around IPA, and your slide actually raised questions because my understanding prior to this was that IPA is assigned to a specific individual, specifically patents are assigned to individuals or a team, but it sounded like you're saying that it may be that the corporation may have rights to it? So
with regard to patents, so the inventor is the inventor, you're right. That's who signs, but the assignment of invention assigns their rights under that patent to the company. So it doesn't, sometimes the actually, it can be either way. The company can be an inventor, but it's most cases it's after, if the patent is already in, if you have a provisional or something already, you're assigning your rights to that patent. And then you can ultimately, once the patent issues, you actually will go to the PTO and have an actual assignment filed so that it isn't in the name of the founders anymore, it's actually in the name of the corporation. So it depends on what time, where you are in the patenting stage and what, you know, and whether the patent is issued or not as to how you address it.
Anybody else? Questions? Karen, I have one final question.
Yes.
For a while, we were hearing a lot of conversation about GoFundMe and other platforms as vehicles for doing early stage fundraising for startups. And then there were some directives that were issued, or at least some kind of information out of the governing body saying, not so fast. Where is that now? What's the
It's still
what's the
in limbo,
implication?
if you will. I think what you know, this was part of the Jobs Act. They opened up crowdfunding, but it created a layer of complication that in practice isn't practical, meaning that there's another exemption that exists for crowdfunding. But it's if you do that, so that allows you to raise money from non-sophisticated, non-accredited investors. But if you don't do it right, you kind of blow up your other exemptions. So you can taint other offerings as it relates to that, and that happened. That's what you've seen subsequently, that people did crowdfunding, and then they did an offer. So what happens in many cases is that you raise money, and ideally, we lawyers will tell you, you need at least 6 months and a day between each offering. So they're separate offerings judged on their same, on their own merits. Because there's a concept in securities law called integration that puts them all together. So in many cases, they were doing these crowdfundings, and then they were doing another offering like 3 months later with just private investors. And that initial crowdfunding blew up the exemption for the investors. So it can, and then you have non-exempt offerings, which are problematic. So I think.
So don't do that.
I think crowdfunding is not. I've had 2 clients sign up with people who paid them. They paid nice retainers to do it. They had good products, good companies, and just like business development people, they weren't able to raise the money, and so it didn't happen. So I'm not a fan.
Okay. Thank you so much. Thank you
My
so
pleasure.
much for coming back to Jefferson.
Thank you.